Yeah. The council's approaching for page 15.
Okay.
Ramirez, Joseph.
Hi, Frank.
All right, folks, Frank's morning is about to hit harder than that coffee you skipped. Let's find out whether this DWI case kicks off with fireworks or falls flat.
Come on.
6 months behind bars and a $2,000 fine, that's way more than a slap on the wrist. That's a straight legal knockout. But don't forget, this is only the probable cause hearing. The court isn't handing down a conviction yet.
Good morning, Mr. Ramirez. Sir, you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir.
Thank you, Your Honor. On April 17th, 2025, in Harris County, Texas, an officer observed a pickup truck change lanes without using a turn signal. The officer observed the vehicle change lanes twice prior to initiating the traffic stop. The officer approached and observed the defendant to be the driver and sole occupant of the vehicle. The officer noted a strong odor of alcoholic.
Alright, real talk, the HGN test, or horizontal gaze nystagmus, is usually seen as rock-solid evidence in DWI cases. But here's the twist, it's not flawless. Did the officer actually perform it by the book? And that refusal to take other tests? Yeah, that could change everything. Stay tuned.
Emitting from the defendant. The defendant was ID'd by his Texas driver's license. The defendant stated that he did not know how to provide proof of financial responsibility. As the defendant responded to the officer's questions, the officer noted an odor of alcoholic beverage emitting from the defendant's breath. Standard field sobriety tests were conducted. A 6 out of 6 was reported on the HGN, and the defendant stated that he could not perform the walk and turn or the one-legged stand. The DIC was read, and the defendant...
Here's your courtroom curveball. Smell alone won't seal the deal. Odor isn't enough to prove anything by itself. You need solid backup, like slurred speech, glassy eyes, or reckless driving. Otherwise, it's like blaming someone for a crime just because they happen to walk by.
Breath or blood voluntarily. A blood warrant was obtained and the defendant's blood was drawn.
Yeah, may I respond?
Please.
Okay, first of all, Judge, the reason, it's not on there for some reason, but the reason he told the officer he can't do it because he had surgery to his back and to his knees. He can't do it. Secondly, there's no mention of any slurred speech, no bloodshot eyes, no swaying.
I was actually thinking about that as well. All you have is an odor of alcohol. Anything, there's no accident. It's just a turn. All we have is an odor.
And just like that, bam, no probable cause. What seemed like an open and shut DWI just flipped on its head. The defense played it smart and turned the whole case into a courtroom curveball. No, here's the real question. Should the odor alone really be enough for an arrest? Drop your thoughts in the comments. This debate's far from over.
Alcohol.
No,
Is there anything else?
He was coming from a tattoo shop and the police officer.
Odor alone is insufficient.
Is he? No, he was coming from a tattoo shop.
Is he what?
He just had a tattoo. Police officer put on. That's just going to that's the odor of alcohol because of the tattoo.
Come
Is he
on,
what?
man.
He just has a tattoo that's put on. I'm just saying. That's the officer actually asked him that question.
Come on, the little alcohol that you put on your skin, you tell me that?
I'm just saying. I mean, the officer actually asked him that question.
You're killing me, alcohol that you put on your skin, you tell me that?
The law
I don't know how it works.
the law structure does state
You're killing me, Smalls.
in the sense that there is the law structure does state in addendums that there is emanating from the defendant's breath. A distinct odor
Yeah.
that's distinct odor we have before we initiate emanating from the defendant's breath.
Okay, that's not enough. All right, I'm going to find no probable cause in your case, Mr. Mears. You know, we have enough death on our streets now. All right, I'm going to find no probable cause in your case, Mr. Mears. You know, $40. We have enough death on our streets now. Get you a car wherever you want to go in this life.